Welcome to another activity from Take Back the Night. My name is Lenore Weitzman. I'm an associate professor in the Department of Sociology here, and I want to welcome you, and I'm going to be moderating the panel. Can you hear in the back? Is it loud enough? Yes? Okay. Let me tell you what our format is for tonight. I'm going to start off very briefly giving some background both on the legal situation and also some of the sociological data on rape and rape reporting. Unfortunately, Linda Fairstein and Liz Lederer were not able to be here tonight. They had an emergency in New York and are going to be staying up all night preparing material for the grand jury. And so Jessica Le Pen, who organized this panel, asked me if I would step in with a sort of a very short introduction to set the stage. But we still have a very full, jam-packed evening. Then Heidi Kreiser is going to speak. She is a survivor of campus rape, followed by Jeffrey Newman, who was her attorney on that case and who represents victims of violent crime in civil lawsuits. Then I'm going to pause and have some questions, and that's because Heidi has to leave early tonight, and I wanted to be sure that we could respond to what she says and to what Jeffrey Newman says, although Jeffrey Newman promises to stay. Then Nancy Gertner is going to speak. She has represented women in civil actions for rape and has also taught courses on sex discrimination law at Harvard and Boston University. Then the Honorable Leslie Snyder, who is a New York State Supreme Court judge and a Radcliffe graduate, is going to speak. And finally, Lynn Heck-Schafran, who is head of the now Legal Defense and Education Fund's Judicial Education Project. And then we will have lots of time for discussion and responses. So basically, we're going to have a pause after Heidi and Jeffrey speak for questions and discussion, and then we're going to hold the rest of the questions and discussion until the end. But after each speaker, if you have a question that's a sort of a point of fact discussion, feel free to raise your hand, your point of clarification. Okay. Oh, and Jessica also asked me to announce that tomorrow night, Thursday night at 7:30, there's going to be a rally behind the MAC, an open mic, and a march. So the traditional law of rape. Let me say, what I'm going to say is a little about the traditional law and how the law has changed, something about the prevalence of rape, why it is so underreported, and why, because of the underreporting, we have such distorted information about rape, and finally, how rape affects all people, and especially all women in our society. The traditional law of rape. The traditional law was when a man had vaginal intercourse with a woman who was not his wife by force or threat of force against her will and without her consent. Each of those elements in that definition is key. Vaginal intercourse, not other forms of penetration. With a woman, not acknowledging that men are also raped. Not his wife. There was an exemption for marital rape. A man couldn't legally be held responsible for raping his wife because the assumption was that with the marriage contract she gave consent for sexual relations for the rest of their lives together. By force or threat of force against her will and without her consent. I think the easiest way to think about rape law is really an example of law that was written from a male perspective and to protect male interests. The greatest fear of men was that someone was going to accuse them of rape. And as Sir Matthew Hale said in 1736, an accusation of rape is easily made, and once made is difficult to defend against, even if the person accused is innocent. So the structure of rape law is a structure of concern about innocent men who are going to be falsely accused, and the entire structure is to protect that horrible event from happening, to make sure it doesn't happen. So that when one looks at the specifics of the laws, such as by force or threat of force, typically what was required was use of weapons to really show that there was force, that this wasn't just a spurious charge. Against her will and without her consent, again, required proof of resistance, of torn clothing and physical injury. Corroboration was another requirement. Her word alone was not enough, but there had to be other evidence, witnesses, semen. It's ironic, but many women the first thing they want to do after being raped is go home and shower and destroy that very evidence that the courts have required. A prompt complaint, it's one of the few areas in the law where there's a requirement that you have to complain promptly, immediately. If you don't complain within 1 to 3 months, then it wasn't a fresh complaint, and it was evidence that maybe you trumped up these charges, fabricated them, and it wasn't truly a rape. And finally, evidence of victim reputation and past sexual behavior. Each of these provisions of traditional rape laws have been modified in recent years. And I know that some of the people in the panel are going to be talking about specific modifications, such as rape shield laws, which say that you can't inquire into a survivor's past behavior. But in most states, the two critical elements in rape are still force and lack of consent. But even the definition of what is force and what is lack of consent has changed. So, for example, force or threat of force can include verbal threats, not just weapons. It can include a size difference between the man and the woman, such as his physically overpowering her. Obviously, it's still much easier to win a case if there's physical injury. And non-consent does not have to be physical resistance. It can also be her word, her no, which has more weight today. For example, in a 1980 case in New York, the man told her that it would be much worse if she fought back, New York v. Lederer, and the court said that those words were themselves force. But what happens if she's terrified and freezes? She may be numb and shock, even though she appears calm. A rape victim, however, is not supposed to look calm. There's sort of this image of what a typical rape victim is supposed to look like. And one of the most interesting innovations in rape laws in recent years comes from feminist research with rape victims, that has discovered what is called a rape trauma syndrome, which is physical and psychological evidence of rape against a woman's will that can be used as evidence that she did not consent. So that some women, after they're raped, are acutely upset, angry, fear, anxiety, nightmares, and are very distraught. But other women seem controlled and in emotional shock, almost numb, and they try not to deal with it so that they can cope with life and get on with their life. And to an outsider, it may look as if these calm, numb people don't look like real rape victims. And evidence of this rape trauma syndrome has been used to show that even though they appear calm, they in fact were raped against their will. They have fatigue, body aches, headaches, sleeplessness, loss of appetite, a number of physiological symptoms that suggest, in fact, it was a forcible rape. But there's still a debate over the standards for non-consent. And in fact, at Harvard right now, there's a debate going on in response to the report of the Date Rape Task Force. Basically, what the Date Rape Task Force says is that she must say yes. Traditionally, the interpretation has been that she must say no. And the Undergraduate Student Council has just responded to the Date Rape Task Force by saying that it's inappropriate to require a yes. What we should require is a no. And I know that I'm going very quickly, but the difference between requiring a yes and requiring a no is, in fact, a substantial difference. The next thing I want to talk about is just very briefly some sociological data, what we know about how prevalent rape is in society. And what we know depends a lot on how we ask the question and to whom we ask the question. If we look at the official statistics of reported rapes, and if you rely on official statistics, you get very different answers than when you do house-to-house surveys. For example, in one of the best house-to-house surveys done by Diana Russell in the San Francisco Bay Area, 22% of the women interviewed said that they were victims of rape or attempted rape. On the other hand, when they were asked about forced intercourse, when the word rape itself wasn't used, then 56% of the women said that they had experienced that. The estimates nationally are between 1/4 and 1/3 of the women in the United States have experienced some form of rape. And of course, it's a much larger percentage if we define it not as rape, if we don't use the word rape, but we talk about forced sex. In a national study of college students, a really excellent study sponsored by Ms. Magazine on 32 college campuses. 1 in 4 women had experienced something that met the legal definition of rape or attempted rape. 27% of the college women. 15% had experienced something that met the legal definition of rape, and 12% attempted rape of the women, and about 8% of the college men. For both men and women, the average age at which this occurred was 18 and a half years. But most rapes are not reported. In fact, the percentage that are reported is very small. The FBI data suggests that only 10% of the rapes that occur are reported. A Ms. survey showed that only 8% of the rapes are recorded, and 1/3 of the women who had been raped told no one at all ever about the incident. The only data that we have for Harvard University comes from a survey done here, and only 5% of the students who said that they experienced any form of unwanted sexual attention reported it to officials. Between 1987 and 92, only 23 cases in total, less than 5 cases a year, were reported to the ad board at Harvard College. I mean, it is clear that rape is a substantially underreported crime. Next question is, why isn't it reported? Why don't people label forced sex as rape? I'm sorry, one answer is that people don't label forced sex as rape. And that's true for both men and women. So in the Ms. survey, of those who met the legal definition of rape, only 27% of the women and only 16% of the men labeled it as rape. These are people who either were raped or had committed a rape that met the legal definition of what was rape. Only 1/4 of the women who met that legal definition of being raped defined it themselves as being raped. If you don't label it, if you don't name it, and you don't define it, you obviously don't report it. Another reason why we have such a great deal of underreporting is that a very normal reaction is denial and dissociation, that it didn't really happen. This was such a nice guy, he couldn't have done it. In fact, what is amazing in the Ms. study is that 42% of the women who were raped saw their attacker again. And another reaction is that women often blame themselves. A final reason, which is the reason one of the reasons we're going to be talking about later tonight, is fear and distrust of the way that women will be treated in the criminal justice system, and the second rape of rape victims that often occurs in the criminal justice system. It's clear that the system often bends over backwards to protect the rights of the accused rapist, but offers little protection for the survivor. I want to say just 2 more things. One is that since most rapes are not reported, if we look at the official statistics about rape, we have a very different impression of what rape is and when it occurs than if we look at data that comes from victim surveys. So, for example, if we look at the official statistics, such as the Uniform Crime Reports, we find that 2/3 of the rapes are committed by strangers. If instead we look at the data from rape crisis centers, we find that only 1/3 of the rapes are committed by strangers. And if we look at data from Diana Russell's house-to-house survey, we find that only 18% of the rapes are committed by strangers. That means that 82% of the women who are raped by somebody they knew. And that suggests very different treatment for dealing with rape and the whole process of rape than if we are thinking about a stranger rape model. Similarly, in the Ms. survey, 1/6 of the college students said that they had been raped or the victim of an attempted rape in the past year. 84% knew their attackers, and 57% happened on dates. Finally, I want to say that rape not only affects the people who have been raped, but it also affects the entire female population. It restricts women's activities. It costs them a great deal of money to ensure their safety. It creates fear and anxiety and distrust in women, and it has a pervasive and long-term, lasting effect on women's psychological well-being, so that it affects all of us. Let me now move on to introduce Heidi Kreitzer, who is a survivor of campus rape.
Thank you. Jersey to the city of Boston. I was 18 years old, and it was my first semester of college at Northeastern University. Two of my sisters had graduated Boston University, and all through my senior year of high school, I was very excited about my college plans. For the first 8 weeks of my time at Northeastern, things were working out quite nicely. I had made a nice group of friends, and classes were going well. Then one evening in November, a friend of mine received an open invitation to a party at Pi Eta Speaking Club. The party was called for November 19th, just 3 days before I was to head home for Thanksgiving break. My friends and I went to the party fully expecting to mingle with the others and have a good time. Unfortunately, our plans did not go accordingly. Late that night, I was forcibly raped by a man at the party in the basement of the house. This attack was overwhelming to me. Within the next 24 hours, I fell into a deep state of shock, which turned into a months-long bout of depression. Almost immediately after the attack, I knew something about me had changed. I didn't yet know what the extent of this was, but it was clear to me that something had been taken from inside me. Since I was unable to function normally, I withdrew from Northeastern in mid-January. I moved back home. It had become impractical for me to remain in Boston because I hardly ever had the strength to leave my dorm room. My new friends became frustrated with me because they said I wasn't any fun anymore. I was unable to walk the city streets to go to classes, and I was up all through the nights because whenever I fell asleep, I was plagued by nightmares. I thought that by moving home, I would be able to relax and get back to myself. Instead, I got worse and worse. I'd been in counseling since soon after the attack, but by April of '89, I was still feeling hollow and broken. My counselor had me on tranquilizers and antidepressants, which only increased the lethargy. From January to April, I was surrounded by loving family and friends and a supportive boyfriend. But by April 7th, 1989, I couldn't take it anymore. In a desperate attempt to make the emotional pain go away, I overdosed on medication. When I woke up in the hospital, I was told by my mother what I had done. I didn't remember doing it, and more than anything else, I was angry. I was angry that this rapist was still ruining my life, that he had almost ended my life. When I was released from the hospital, I decided I had to make some drastic changes. I had to gain control back over my life. The first step was to get into more intensive therapy. The second was to go to Cambridge and repeat my reports that I had originally made to Northeastern to the Cambridge police. Once I had steps 1 and 2 in place, I obtained the services of Jeff Newman, a civil attorney who could help me in getting justice. When Jeff and I first met, we sat down for several hours and I explained to him exactly what happened. We determined that Pi Eta had failed in certain responsibilities and could therefore be held responsible for my being raped. The civil process began. It took us a full 2 years. In that time, I was given a crash course in the justice system. The defense attorneys were free to ask me all kinds of questions. I was asked if I'd ever used birth control prior to the rape. I'd asked if I'd ever had an abortion before the rape. I was asked these types of questions all through the discovery period and all through the depositions. My entire private life ceased to exist. The defense attorneys got a hold of all my high school records as well as all my medical records. It was extremely upsetting to me, but it also gave me the strength to go on. It proved to me all the more that I deserved to win this case. Whether the defense attorneys wanted to admit it or not, I knew what went on in that room. I knew that I had made it clear I didn't want to have sex. I knew that I had begged him to get off me. I knew that I had pleaded and struggled as much as I could. He was bigger and stronger than me. He knew what he was doing. He had probably planned the assault hours before. I was shocked by it. In 1988, people weren't talking about date rape the way they do now. It wasn't written up in every magazine. There were no TV movies about it. It was just a silent crime. But attorneys like Jeff had an idea of what was happening on college campuses, and Jeff knew of an excellent way not only to help me become a survivor, but a way to ease the pain for the next potential victim. Being the rape victim in a civil suit is a difficult experience. It was very helpful, though, in the recovery process. When Jeff first met me, I was shy and very afraid. I didn't have the courage to voice my opinions or the strength to take care of myself. I had become very dependent on my loved ones. By the time we settled the suit last April, I had grown and changed a great deal. Standing up to the defense attorneys and the invisible shadows of Pi Eta members and the assailant was the hardest thing I've ever had to do. It was also the smartest. I found that By looking deep inside me, there was a woman I had never known existed. In the 3 years since being raped, I have become stronger and much more confident. The knowledge that I am far from the only woman to be raped on a college campus motivated me all through the lawsuit. The rape already happened to me, and I can't erase the memory of that. Knowing the devastation of being raped that it had on my life in my opinion, it is a shame that the silence surrounds this crime, and I think that that is what has led to the pervasiveness. Experts say that rape is a crime of control and anger. I hope that it becomes that for the victim too. I hope that she gains control over her life and uses her anger to bring about change. If more rape victims began using the civil process, they'd stand a better chance of getting justice, and potential criminals would hopefully begin to rethink their actions. I have no regrets about my civil suit, and I am thankful to my attorney that he was successful in helping me become a rape survivor.
Newman, who represented Heidi Kreitzer, and who represents victims of violent crime and civil suits.
I'd like to say first that I was very lucky to be asked by Heidi Kreitzer to represent her, and I'm grateful for her comments, but in good part, Heidi Kreitzer's success derives from Heidi Kreitzer. And while I did what I was trained to do and had done before, the result in Heidi's case, which, if those of you who don't know it, was a resolution by settlement just prior to the trial, is Heidi's doing. And I can tell you from my point of view that Heidi did not just survive the occurrence, but from knowing her and watching her change, Heidi dominated the occurrence itself and the system and all of the adversaries that she faced, and that I was there watching this evolution and can tell you that the change has been amazing, and she really has become a different person, and she is the person and the case that I look back to when we go on to others. Heidi's case was a very rigorous, heavily defended, intensely fought piece of litigation for nigh on to 2 years, and it was attended with heavy publicity. At one point in time, defense attorneys were successful in gaining a Superior Court gag order against myself and Heidi coming into the trial when press was most attendant. We took that directly on an emergency basis to an appellate court, and Judge Peretta, in a very snappy decision, rebuked the defense for what they had done and said that not only has nothing been done, but it would be effectively unconstitutional to stop her from talking to the press on what had become not only a case but a cause. And I laud Heidi for sticking it out and for being successful. I have no doubt that had we gone the full route to the jury trial, that we would have been successful. In order to just tell you how different she is, when Heidi first spoke to me, she spoke in whispers. I could barely hear her. And I wanted to tape record one of her conversations, and it was so quiet that we couldn't hear it on the tape. She recounted to me in muted tones what had happened to her. By the end of the case, the defense attorneys, in approaching us for a resolution, a final resolution on figures that we had discussed, tried to link it to a confidentiality agreement, which is common in litigation. Heidi instructed me in no uncertain terms that a wholesale confidentiality agreement would be unpalatable to her, and she then had taken reins in her case and was telling me effectively what her wishes were, and that is the way these cases should be run, and that is what we like to see in litigants. Heidi had become a different person. I was asking Heidi which way we should go in the case, and in perspective, Heidi's use of the civil process was highly effective and what it was meant to do. I'm just going to say a few words from my point of view as to what the civil process in rape cases is as it relates not only to rape victims in what's traditionally been known as stranger rapes, but now acquaintance date rapes. I have a law firm, and we primarily represent victims of violent crime. And that stemmed in part from work we did in landlord-tenant law. And traditionally, the case that we see is a tenant who has requested repeatedly for a landlord to fix a lock on a door or a window, and landlord repeatedly refusing to do so, and assailant gaining entry and causing the rape. That is the case that comes in most often. But over time, that changed, and we're now seeing other rape victims, and some of them date and acquaintance rape victims. And those are much different cases, both in civil and criminal law. The police, at the outset, when they interview the rape victims, we find look askance at these cases, and sometimes are, in their own perspective, so dissuaded from even viewing the case that the victims themselves become turned off to the system. That has some basis in the sense that police are trained, as are the district attorneys, to evaluate the case on the basis of a reasonable doubt, the standard that has generated in criminal cases. A very difficult standard, and Nancy Gertner will talk about that, I think. But it doesn't mean that date rape is not a crime and should not be prosecuted. And we have fought hard against some district attorneys who have had a traditional hands-off approach. That having been said, I would say that in Massachusetts, my experience is better than out of state. I have a case pending in New York courts, and I won't say too much about it because I think we have a New York judge here, but what did happen in that case, and I can relate to you as a matter of record at this point, was on the day that I was hired, the district attorney, an elected official in New York, said that he was going to plea bargain the case. As a matter of fact, he was going to let the assailants admit to sufficient facts. This was a gang rape at a college, and there were witnesses. It wasn't a question of whether it occurred or not. And my client didn't want that. And we talked to the district attorney, said, would you please meet with us? And he said, absolutely not an out-of-state attorney. And it was only when we said that this was a matter for the press that he stopped what he was doing and took attention and met with us and, in fact, drew the process forward. The case was eventually ended with sexual assault, even though the grand jury rendered indictments for rape 1. And the case draws forward civilly. The point is that it's only now coming about that the district attorneys, I think, are looking at these cases more seriously, and when they feel they can get a conviction, they'll take the chance now, whereas even a couple of years ago they wouldn't. The problems of proof don't preclude a civil case. The two, civil and criminal, run along the same tracks. The civil case is not dependent upon gaining a prosecution. It's helpful if you do in a criminal case because you, as a civil attorney, can use that as prima facie evidence in your case, telling the jury that this helps prove the occurrence. But most of our cases that come in, the assailant either flees or is never caught. In Heidi's case, we simply couldn't find him. He left her at the party, and it doesn't mean that there isn't a viable civil claim where the quantum of proof is by a fair preponderance of the evidence. In addition, civil counsel often have resources that can't be rendered to the degree that they are in a criminal case where there's so many cases burdening a district attorney's office. So we are careful to screen our cases. Those that we investigate heavily. In Heidi's case, I think we initially interviewed over 60 or 70 people. And that is a resource that rape victims may not have in a criminal case unless it's a celebrated criminal case. And so in perspective, I think that Heidi's case is an example of how the civil claim is now being used as an excellent tool for rape victims, even when the criminal case is not possible. Used for not only gaining fair compensation, that is money to assist in therapy or whatever it is that's going to make the victim's life better, but also for success and proving that the system can be used even though the odds are against you. And I think going in these cases, particularly acquaintance and date rape cases, where there is no evidence oftentimes, where the studies show that acquaintance rape victims, as opposed to stranger rape, feel more guilt, so they may not tell people right away. Even in those cases can be won successfully in a court of civil law because of the standard that's been put forth. As to the occurrence in a fraternity. This is not an infrequent occurrence. It's now coming into the press more often. Paternity cases, of which we have several, are difficult cases. The fraternity members, even if a member wasn't involved in the rape, they tend to close ranks. But there is a great difference between talking to someone just after the occurrence and talking to someone in a deposition after a case has been filed, where the perspective goes beyond just the 3 or 4 years when you're in college and a member of a fraternity, and you're concerned as the member of your future reputation and telling the truth. I can tell you, after several hours where that is relayed to that person, the truth does often come out, and you start getting little details here and there of what actually happened, and then the word gets out, and the fraternity members do not stay together after the case is filed. The filing of a case has a very sobering effect on members of the fraternity and people who really don't want to come forward because they're concerned about the club and the group. I want to just mention briefly the effect that I feel the press has had on litigation and the ability to establish these cases, just in the same way as the filing of a lawsuit has the effect to open doors to the truth. I think the spotlight that the press has put on these cases has had a tremendously beneficial effect. People, I think, are now aware that they have tremendous liability if, for example, people who are obviously intoxicated or serve further alcoholic beverages and that person commits a sexual assault. There is law in Massachusetts and elsewhere that is a foreseeable event from giving that visibly intoxicated person further alcohol. And if there's any question to that effect, there's a case on point in Massachusetts, which is Carey versus New Yorker of Worcester. And I don't want to get too legal, but I'll tell you what our Supreme Court, our appellate court said. Serving hard liquor to one already drunk has a consequence which is not open to successful dispute. Such action may well make the individual unreasonably aggressive and enhance a condition in which it is foreseeable that most any irrational act is foreseeable. In that case, it was a shooting. And so you have different events coming together to cause this occurrence. The most egregious circumstance at a university level that we're seeing is where instances of individuals are repeated offenders in the universities come into knowledge. They're aware this is occurring. In one university, there was a young fellow who committed 3 separate acts of rape on campus. And it was published now, so it's no secret, that after a judicial board proceeding, the third one, this man was caused to write a paper on what it was like to commit sexual assault and what he should do to avoid that later on. He eventually was asked to leave the campus, but to this date there's been no prosecution. And the 3 women came forward and brought a complaint against him at the university. This is not an infrequent occurrence. The university setting has traditionally been a place where instances of sexual assault have not been defined as rape and have been brushed aside. As a matter of fact, victims have been asked to go through the internal judicial process as opposed to the official criminal process. I see this changing in rare instances and only changing when there are major lawsuits. It has nothing to do with the legislation. I think the universities are, in rare instances, becoming concerned about a drop in enrollment because of the intensive competitive nature. But that's a rare change, and I think it's still the generalized understanding of administration that what goes on behind closed doors is really not their business. They don't want to see a major ruckus, certainly not a major criminal prosecution. And that makes it hard, but it doesn't make it impossible. And again, one of the ways that we can draw the criminal process into the whole matter is by involving civil attorneys at the outset so as to try and keep things straight. I think that the role of the civil case helps to destigmatize the issue for rape victims. And Heidi and several others of my clients and others that I've seen attest to this. Generally, if you go through the process and you are successful, it is a changed person that you see. Heidi is nowhere near the way she was before. I think that the case, if there's nothing wrong with the case becoming a cause, and that these cases, civil cases and criminal cases, should be used as much as possible and as much attendant press as possible, still allowing for a fair trial. I think that Heidi, I'm grateful to Heidi for hiring me, and I'm grateful for her success, and it really is to her that the acclaim should go for what happened. No, I haven't.
Okay, we're going to pause for questions. There are no mics back there, so I'm going to, if you can try to speak loudly, and I definitely will repeat the question. Yes?
Do you think that your goals might have been more effectively achieved if the case had gone to trial?
Question was, do you think your goals might have been more effectively achieved if the case had gone to trial?
Is that to me? If we had won. Sure. I think, to answer your question, my experience is that the greatest effect that these cases have derives from a jury verdict, where a jury of the community decides what's going to happen. Notwithstanding, my job as a civil trial attorney is directed in terms of my focus to the client. And while I would like to see great social benefit from a string of major jury verdicts, I have to decide the client's best interests, which in my mind are get her more in settlement than the jury may give, and then my job is satisfied.
Stephanie?
Mr. Newman, you said that you felt the press had beneficial effects on highlighting the seriousness of rape. What do you think the effects of really publicizing how such as those in the community trial? Do you think that they could have effects another way also? Like, how do you think
The question is the effects of the press and publicity around rape cases, and Mr. Newman said that there was a positive beneficial effect, and Stephanie's asking, what about the William Kennedy Smith case? Can there also be a negative effect?
My own personal point of view on that particular case is whatever negative effects there may have been short run because the victim lost have subsided, in that the public was given a window on the judicial process, and that can only be beneficial in the sense that people kind of deify and are fearful of it, and that I think many more rape victims will come forward having seen it than not.
Yes, in the back. I know of nothing whatsoever. I mean, all the data we have from every source that we have data, everything from official statistics to house-to-house surveys to informal reports from students of Harvard about how extensive date rape, acquaintance rape is and how little is reported, I think would suggest the opposite.
I've heard it said that the FBI has statistics on that, but I don't
No, can I just, I mean, if you're hearing this is such a dangerous statement. Let me tell you that, for example, yesterday, the government released the latest National Crime Survey, and it says in the body of the text, we acknowledge that our report on rape is seriously underreported. I mean, that's right in there in the text from the U.S. government, okay?
Thank you, Elaine.
I have the feeling that he might.
Yeah.
Did everyone hear that? Okay? Okay.
Presently, the range of verdicts in these types of cases is between $500,000 to $1 million or $2 million. That generally is paid in part from insurance and in part from the university's monies, and that if the facts warrant liability, an analysis done liability, I don't think there's any question that civil attorneys will take these cases. I would like to go back to your last question, if I could, just for a moment, because I have heard Alan Dershowitz mention those statistics. The facet of the uniform crime statistics that I believe he's mentioning, because I have those compiled in my office, is a small section dealing with what he deems to be misreported crime. That is, women who claim a rape occurred and it is later determined that that did not occur. The statistics derives from reporting of rapes, but not non-prosecution of those rapes. And there's another section of that report which explains that in more detail. The non-prosecution does not mean that the crime was established not to have occurred. It means that there was a report and no prosecution. That statistic is one that I believe is going to be eliminated from the uniform crime stats and has been roundly criticized. So that I have the greatest respect for him, but I think he has taken that a little bit out of context from my point of view.
Just a point of clarification for Mr. Newman and Ms. Renner. How exactly did you make the decision to go to civil route versus the criminal route? Is that based on the fact that the perpetrator couldn't be found, based on the amount of evidence? How did you make that decision?
The question was, why did they decide to go the civil route rather than the criminal route in this particular case?
Heidi went both routes, and they went at the same time. She went to the police, and she told them they did their investigation, as did we, and there was an assailant who it was thought was her assailant. There was simply not sufficient evidence to bring that person forward based on what occurred. But there really wasn't a decision that was made. One goes to the police. It's out of your hands, in effect. At that point, they take it over. She decided to come to me for whatever reason.
Yes.
I actually have a copy of the reported Bureau of Justice statistics, the National Crime Survey, which was distributed by the AP nationally. It appears in Crimson, for example. It doesn't have a disclaimer about its over-reporting rape. Actually, there is a paragraph that comes with the report that says that the criminologists consider the survey of victims, which is what this is, a more reliable barometer of crime than the Federal Bureau of Investigation's Uniform Crime Report. Now, this particular set of statistics indicates that the incidence of rape last year increased dramatically. In fact, the headlines make a lot out of that, but increased from 0.6% to 0.06% to 0.1%. That is an instance of 1 in 1,600 to 1 in 1,000. Now, the numbers that you, Ms. Weiss, were quoting were considerably higher than that. Well, I'm disposed to prefer Ms. Magazine reader surveys to Bureau of Justice statistics in other cases. Here, the discrepancy is so large that it appears to me that there's some explanation might be warranted. Now, one possible explanation comes in the language that you used in explaining your result. You suggested that people might have been answering a question as open-ended as, were you the subject of unwanted sexual attention? And that might have, at least with respect to the Harvard survey, that was the question that was asked. And you were using that as a point of data about rape statistics. And I take it that's a very different question from a question about rape or attempted rape. This particular statistic is rape or attempted rape and suggested an incidence of 1 in 1,600 to 1 in 1,000.
The specific thing you mentioned, the Ms. Magazine, it's not a Ms. Magazine survey. It's a study that was financed by Ms. Stern.
I'm sorry, it was financed by the National Institute of Mental Health.
Okay, thank you. And the book was
Right.
it was reported in. I never called it rape. Was underwritten by the Ms. Foundation. It was a study of 32 college campuses, random surveys of women and men across the United States. 27% of them said rape or attempted rape. 15% of them said rape. So that's just so much larger than the FBI victim surveys. It also corresponds with all the data we have of data from rape crisis centers and all the data we have from house-to-house surveys. I think that it is a much more reliable statistic of, in fact, what is going on in the population because of all the reasons we know why people don't report rape. And they don't report it because of the way people who do report it are treated. You want to add to it? Sure.
No, I just hope we get to how people are treated.
Okay, we are going to get to how people are treated. Are there any other questions? Yes, Wendy.
I have a question for you, I guess. The way we define rape, if rape is any kind of forceful insult, some rapes, it seems to me we lose the sense that some rapes are worse than others. And I'm not suggesting that all rapes are horrible, but all rapes are not equally horrible. I think based on common sense and experience that it's better to be date raped by someone you know than it is to be gang raped.
Can I answer?
By several men who you don't know, who you feel like it's better to be in a situation where you're not scared to your life than to be in a situation where you're scared to your life. I realize it's a change in the last 2 years, and that makes it very different. But it seems to me important to recognize that there are some rapes that are worse than others. Now, that's probably a very unpopular statement.
It's also wrong. Okay?
Lynn wants to answer. Go ahead.
That's, I perhaps said that in a harsher tone than I meant, but I feel very strongly about what we take as common sense in the world. We take as common sense in the world that if you are attacked and a victim of crime, you'll go to the police. The fact is the vast majority of people who are victims of any kind of crime never go to the police, and vastly more people who are sexually assaulted do not go to the police. The assumption is that if you are being beaten black and blue by your husband, you will leave the house. That's common sense. The vast majority of women who are in those situations do not leave the house. Women who are victims of sexual harassment do not quit their jobs. They need to put food on the table. There is extensive research that comes out of Beth Israel Hospital here in Boston on the difference between what's called blitz rape, being attacked by a stranger, and confidence rape, being assaulted by someone you know and in whom you place trust. In both of those situations, the individual fears for her life while the attack is going on. It may appear to us as observers, and maybe Heidi would speak to this, and Heidi, I don't mean to ask you to speak to more than you want to speak to, so please understand how I invite that. It may appear to us that not a great deal of force is being used, or there's no reason why you should be afraid. But the fact is that to the woman who is experiencing this, she perceives her life to be in danger, whether she's with a guy pushing her down on the bed in the hotel room or a frat, or someone out on the street. And the sequelae, the consequences of blitz and confidence rape, while they are somewhat different, are very serious for both, and in confidence rape may be even worse, because the entire sense of trust that you have in the world and in other individuals is destroyed. And in fact, the worst kind of rape is usually marital rape, because there the most extreme sense of trust is totally destroyed. So I think that this is so dangerous an idea.
However, if I may, a number of jurisdictions have considered your idea and have attempted to propose statutes which do have various degrees of rape and which do recognize differences among rapes. So what you're saying is not absurd, so you shouldn't think that the reaction is unique to you. Most of those jurisdictions have decided that that is not a satisfactory way to proceed.
It's very dangerous. Excuse me, I'm barking. It's very dangerous, it seems to me, too, because it buys in ultimately to the situation that we've been reacting to, which is the notion that it is not serious to be date raped. If you try to come up with a hierarchy here, of some kind of objective hierarchy, you really return to a point that we've just left. And so it doesn't seem to me that the enterprise is worthwhile to do.
Well, are you suggesting then that sentences should be the same in all rapes, regardless of the circumstances, regardless of the consequences?
No, I would never say sentences should be the same all across the board in any crime at any time.
But sentencing, you're getting into a very complicated area. As someone who has to sentence people, there are many, many factors that go into every sentence, and certainly the difference in types of rape, if there is a difference, but the facts of the particular situation are what you would consider the defendant's background as the judge, as well as trauma to the victim, but that's much harder to quantify. I'm sorry,
I just wanted to mention from one of Mary Koss's studies, when Heidi talked about the fact that she overdosed, this is a study that Mary Koss is the person who did the NIMH study that Lenore was describing, did trying to analyze the differences of stranger and acquaintance rape or the differences in the victim's experience. And she found that the groups did not differ in the percentage of victims who had considered suicide after the assault. Among all victims, 27.8% had considered suicide to the point of thinking about methods.
Okay. I'm going to move us on and introduce our next speaker, who is Nancy Gertner, who has some form of laryngitis?
Yes.
Slight. Okay. Nancy Gertner is well known as a person who has taken many leading sex discrimination suits on behalf of women in academia, has been a true pioneer in this area. She has also taught sex discrimination courses at the law schools at Harvard and at Boston University. And she has represented one person in a civil action in a rape case.
No, you got it wrong. No.
Criminal action.
First, pardon my voice. I think that it's unheard of that I would lose my voice, but I have in fact lost it. What Lenore has gotten it wrong. The vast majority of my civil work is representing women in reproductive rights cases, representing women in sex discrimination, sex harassment, civil rights cases, and I, like Jeff, also do civil actions for rape as well, suing landlords, etc. I have, in the criminal part of my practice, I represent women, battered women who have killed and other women defendants, and I represent men as well in a host of other kinds of crimes, alleged crimes. I have, however, represented one man accused of rape in my 20-year career, and I want to say that up front because it has, in fact, had a result which I think is incredible and not a result that I would have wished, and frame some of my discussion. So let me start off by saying I come at this in a very bizarre way, where 99.9%, I would say my entire career has been framed by my feminism and by my desire to bring to bear these skills for women's rights, for civil rights. And that has led me both to criminal law and to civil law, since in most criminal cases I strongly believe that people face a juggernaut of government power, and most people need the services of as good an advocate as they can get. On the feminist side, I described some of the cases I take, and I'm here in part, I think in part I lost my voice too because I lost a case that was terribly troubling today involving a battered woman who had killed her husband and who was then sentenced to a woman had killed her husband after years of battering. We won a manslaughter verdict, which seemed to be the best that we can do, and then the judge slammed her with a 15 to 20-year term. She had no prior record. So most of my experience as a criminal defense lawyer is framed representing people in situations like that. But as I said, I'm also a criminal defense lawyer, and that does shape some of my other perspectives. I chose for most of my career never to take rape cases, in part because I understood that whenever I took a case, I poured myself into it. I didn't know any other way to do it, and basically didn't want to take rape cases for two reasons. One had to do with me, and one had to do with the system. The part that had to do with me was that once I had received any notoriety, particularly as a feminist, the last thing I wanted to do, that my phone rang off the hook from defendants who wanted me to represent them in rape cases. It was clear that they had realized it would be great to have a woman criminal defense lawyer represent them. And I declined
and still do, because my sense was I didn't want my personhood. It's one thing to use my skills. This was using my symbolism, and I didn't want to use my symbolism for these purposes. And the second reason was I'm a decent criminal defense lawyer, and I understand what it takes to cross-examine a woman victim, and I didn't want to be on the other end. I simply didn't want to do that. I knew that if once you determined that you were going to represent someone, you had no choice but to use all the tools at your disposal, and I simply did not want to be in that situation. Let me describe a little bit about where this has taken me, and then I'll return to the one case that I have taken, since I feel like I need to make full disclosure, since I told the sponsors of this panel about this one case and that maybe they didn't want me on the panel because of that. But let me tell you a little bit. In one sense, the law of rape has swung between two myths. One is the myth of the false accusation, men's fear that lurking behind every rape accusation is a false accusation. And in the early years, some of what Lenore is describing, the law was built around protecting men against false accusations. The law very dramatically reflects social and sexual mores, and so the notion was that women would never be straightforward about sex. And so therefore we had more to fear, so it was said, with the myth of false accusation. The other theory is, of course, the theory of, and some would say, and perhaps Dershowitz would say, the myth of the unredressed rape, the myth of the reverse, the myth, that is to say, that women are not reporting when they have been raped. And some would say that the pendulum has swung too much in that direction in recent years, and I don't agree with that. But I think you can, as I can describe to you, it really has been a swing from one end of this pendulum to the other. In the beginning, and in fact I culled together notes that I had written on this subject in 1980, 82, 83, 84, and I could watch the swing according to the notes that I've taken. You can watch the swing in two directions. One is the definition of the crime. What constitutes the crime? What constitutes consent? What about the relationship between the parties? That's one area where you can track the swing. And the other area where you can track it is what is the proof? The definition of the crime, what we think is bad about this conduct, is critical. And in the beginning, the crime was defined in terms of the woman's consent or lack of consent. And the focus of the entire case was on the woman. And one can see, in effect, three kinds of situations. I am a continuum builder. I build continuums in my mind. And so the law of rape, when you talk about the definition of the crime, you think of it, at least I did, in terms of three situations. One where she said no, and he had sex. Two where she said nothing, and they had sex. And three where she said yes. Now, ironically, in the bad old days, when she said no, that wasn't good enough. And Lenore described that a bit. Saying no was not good enough. You had to scream and yell, and there are all these horrifying, disgusting cases about how women didn't scream and yell enough. He threw me on the ground, he put his hands on my face, but that was not enough because she had not resisted enough. It stemmed from the old notions of chivalry. If your virginity was on the line or your chastity was on the line, goddamn it, if you didn't push to the nth degree, if you didn't fight to the nth degree, it couldn't have been unconsented to. So in the bad old days, the crime was no was not enough. In addition, in terms of that definition, in terms of relationships, the only relationship that mattered was a stranger situation. There was no such thing as marital rape, and there was no such thing as date rape. And in terms of the proof, and this as a criminal defense lawyer I've watched over the years as proof changes. In other words, what we consider to be meaningful evidence of what we're trying to prove really changes. In the bad old days, for want of a better word, there were statutes all across the country that, because everyone was so concerned about the myth of false accusation, the statutes required corroboration, which was virtually unheard of in a rape case. And in any other case, you never required corroboration, and that was because basically courts found the crime unbelievable. The fresh complaint doctrine also arose from this same kind of impetus. And fresh complaint doctrine did not then and does not now reflect women's experience of the world. The notion that once you are raped, essentially the courts were saying that unless a woman behaved as follows, we wouldn't believe it really happened. And that is unless she is raped at time one and then at time two runs screaming to the first person she sees and says, I've been raped. And of course studies suggested and logic suggested that women don't do that they will deny initially. that they will race home, that they will be ashamed, that they will feel horrible. In other words, the law was requiring women to do precisely that which women couldn't do or frequently didn't do. And yet the measure of whether you were telling the truth was how quickly you told about it. Now, in the rest of criminal law, that is not the explanation for delay in reporting. Could be, I was horrified, or I'm lying. It could, in fact, be either. And so the law put the imposed fresh complaint requirements on rape, and then it really does spill into other areas. But the worst thing about the law of rape in the bad old days was, and again, this is how evidence law reflects social mores, was that in a rape case, you could introduce evidence of a woman's reputation for unchastity in order to show that she was likely to have consented. And this was because in those days the feeling was, if there ever was those days, or at least the myth was, that women who were unchaste, whatever the hell that meant, whatever it means today, I don't know, but whatever it meant then, were more likely to consent than others. What we've done and started to do all across the country 10, perhaps 15 years ago, was to say that is offensive to modern social morality, modern sexual mores. That's offensive to that, the notion that once you've consented to all time. And so that was, but in the past it was believed, rightfully or wrongfully, that was relevant evidence of consent. Reputation, not only reputation for unchastity, but also specific acts of unchastity to prove that you're likely to have consented. Likewise, we projected that. So the pendulum that we were reacting to 10 or 15 years ago was a pendulum that treated rape victims in a way that no one else was treated, that approached every rape case with extreme skepticism, so that barriers were raised up in situations that they never were in any other situation. That led to a change in the definition of rape. And so now I get to my continuum again. When she says no, no is enough. The requirement, although it's not clear all across the country, is more and more that the word is sufficient, that you don't have to scream and yell and kick and et cetera, that no is enough. The intermediate category is still a problem. When she says nothing, one way that I've put it is, who has the burden of ambiguity? If the situation is ambiguous, does he have a right to touch? Does she have a right to rely on not being touched? My personal feeling is that in any other situation in the world, when somebody cuts you open for an operation, they got to get a yes. Right? If I say nothing, it's not sufficient. I think sex should be the same way. Ambiguity is not sufficient. My husband won't like me to have analogized sex with having an operation, but in any event. And emotionally, I have experienced rape. Well, so it's an excellent analogy. The law is not where I just described it. The burden of ambiguity is still on the woman, to some extent. If she, by her, at least that's a fluid area. Let me come back to that in a minute. And then obviously if she says yes, yes means yes. I'll get to that in a minute as well. The proof, most of the laws nationwide in which there have been some kind of formal corroboration requirement has fallen, but there still is a preference for fresh complaint. And I said because, in fact, elsewhere in the criminal justice system, it is true that you can always bring out delayed accusations. There may be an explanation for a delayed accusation, but you can always bring out a delayed accusation. And in some measure, the rape law is not reflecting very differently at this moment from the rest of the criminal law. And then the other beneficial development, extraordinarily beneficial development, is the rape shield law that finally put an end to this notion that that a woman's character, nowhere else in the criminal justice system is character permitted to prove conduct. That's a standard line, a standard prohibition in the criminal justice system that character is not permitted to prove conduct, and yet it had been with women, reputation for unchastity. That is eliminated now. Any reputation of unchastity with certain exceptions that I'll describe later. So the rape shield law has really made a substantial change, recognizing the change in sexual mores. And now we've also broadened the definition of privilege so as to include rape counselors as well, recognizing that women may not have the money to go to psychiatrists, and psychiatrists were protected, or even social workers, and social workers were protected. So we have laws that allow for rape counselor privileges. The problem is, with all of that, we are still in a forum, that is to say, a criminal case is still in a forum which is horrible for all its participants. And horrible probably, well, I mean, I have to say as a criminal defense, but horrible for the defendant, horrible for the victim, a system which is incompetent and unjust to all its participants. What does that mean for rape victims? Well, here are the problems. If she says, as I said, getting back to the definition, if she says yes, there are those who would say that even when a woman says yes in a date rape situation, she doesn't mean yes, that there are all sorts of psychological, social pressures on women to say yes when they mean no. There are those who would, in fact, try to push the boundaries of rape to even include situations where a woman says yes but means no. I, in fact, believe that to be the case, that for reasons that have to do with our upbringing, we don't even know how to say no when we mean no. But there's a substantial question as to whether the criminal law, liberty interests, can reflect that kind of a situation. Then the intermediate situation of where the woman says nothing. Susan Estrich proposes, and I heartily endorse this, that where a woman says nothing, where the situation is ambiguous, can a man then say, gee, I made a mistake, you know? She gave me inconsistent signals, I made a mistake. Can the man then say, I had a right to go forward, I had a right to rape her, I had a right to have sex with her? And what some commentators like Susan Estrich would say is that if he has made a reasonable mistake of fact, that's one thing. But if it is unreasonable, it's quite another. The definition of reasonable is a definition that we build together. In other words, when a man hears that a woman says no, he can't reasonably believe that she means yes. When a woman comes to his door and she's dressed as people are dressed today in a miniskirt, he can't say, God, I could have sworn she meant yes. In other words, the definition of reasonableness should cover some of the problems in this intermediate category where the situation is ambiguous. But make no mistake, it means that everything the woman did that night is scrutinized. Everything that she did that the man knew about is scrutinized in terms of the question of what his intent was. And that's a problem, and it's troubling, and it's hard, but it's inevitable in the criminal justice system. And then a situation when she says no is what I've already said. But that, in other words, just looking at the definition of rape, what happened that night, not getting into any of these issues of reputation for unchastity, etc., it is a brutal process. The defense lawyer will examine what will try to do what people have done from the beginning, which is talk about the way she was dressed, what she was thinking of, what she did that night. The cross-examination of Patricia Bowman is classic. But where it bears on whether or not he intended to rape, it must come in. What we can do in this process is to learn how to educate juries and learn how to educate judges. What we can do in this process is the next time a criminal defense lawyer says, well, why were you dressed like that? The jury we will have educated to say, that's ridiculous. Or the prosecutor will learn to say, don't you think those times are over? But the notion that this information isn't admissible, it is painful when it's admitted, but it really, these issues of sexual mores have to be played out in court, and that's the way to play it out. What I'm saying essentially is no way to keep it out, no way to protect women from these inquiries. It's terribly troubling, but they have to come out, and we have to address the social values that they implicate. In terms of proof, we have to show judges and juries why victims do not come forward. We have to introduce evidence about why women cringe to talk about these things, why they don't want to talk about things. Is it admissible whether or not someone filed a fresh complaint? Yes. How can we do to change the spin on it? That's something we have to change. Prior relationship with this defendant is admissible, not reputation for unchastity, but if they ever had sex before, is admissible. It doesn't mean that she consented to every occasion, But in every other criminal case, the prior relationship between the victim and the defendant is admissible because it bears on what was in his mind. It bears on what he understood in the situation. And so in this respect, rape law is no different. It is painful, it is difficult, but it will come out. Impeaching the victim. Every victim is impeached. Impeaching the victim by trying to show that she's lying, that she has a motive to lie, that there were prior false accusations. Again, does that necessarily come out? I think it does. But how can we begin to provide a social context so that criminal defense lawyers are not saying, well, she lied here because she was embarrassed about sex, when in fact people are not today? In other words, again, you really are talking about playing out before the jury the debate that one hopes is going on across the country and has gone on as a result of the Bowman cases. It will be painful, but it's unavoidable where someone's liberty is at stake. His character, there's enormous tumult about whether or not William Kennedy Smith's prior rapes would come in, prior accusations of rape. It's a very troubling situation for a criminal defense lawyer. It's a wonderful part of our society, I believe, that when a human being is accused of crime, if they were bad 3 years ago or 10 years ago, that doesn't come in, that we don't believe that once you've done something wrong, your character is forever damaged. In the battered women syndrome cases, when I represented, the woman's name is Lisa Grimshaw, the fact that she was promiscuous in her teens was not relevant to any issue in the case. The fact that, in fact, she may have even been violent as a juvenile was not relevant to the question of whether or not she killed her husband under self-defense. But those are in other words, I was representing women with exactly the same issue in the William Kennedy Smith case, and I was very gratified that we don't believe that character can prove conduct. The problem here is juries, ultimately. No matter how we change the definitions, juries are not convicting of date rape. And juries are not convicting of date rape because we haven't educated juries and the public about it. Let me tell you one other, let me just sort of end, this is a little bit disconnected, and I've gotten my 3 more minutes or you die message. Part implicit in the defense of rape cases is access to information, so that the defense lawyer gets access to information concerning the relationship with the defendant, information about prior accusations of rape, and information about the circumstances of the fresh complaint. Most defense lawyers, once you've reported a rape to your neighbor, the first thing to do is the defense lawyer will interview the neighbor and say, what did she say? How did she appear? That's part of it. In the case that I am resoundingly criticized for, and I'll say this very quickly, a case called Commonwealth versus Stockhammer, is a friend of my, close friend of my son of a close friend of mine, called me up and said, my son has been accused of rape, will you speak to him? I had been pure up until that point. I never even took the calls of people who asked for my services in a rape case. I have a son's now 4 and 6-year-old, and this was a close friend of mine, and I thought I at least had to talk to him. I talked to him, and for reasons which I don't have to go into here, I was completely persuaded of his innocence. I still didn't want to take the case, because still didn't want to. One of the advantages of being a private lawyer is that you don't have to take every case that comes along, and so I passed it on to someone else, assuming that he would win. Critical fact in the case was that the woman had invited him to her family's house 2 weeks after this supposed rape. In other words, had behaved afterwards in ways that were dramatically inconsistent, so we would think, with rape. Now, it could have been that she just didn't know how to behave, but still, there certainly was something to be concerned about. And the young man was himself a virgin. It was his first sexual experience. Nothing gave a clue to this. For various reasons, I don't want to retake the case. I felt very deeply, and every woman in my office felt that he was innocent. The case was lost. He was about to go to jail. They had decided to waive a jury, which was a crazy decision for him, since in fact the judge felt the political pressure. The prosecutor felt the political pressure, appropriate political pressure, to bring this kind of case, and I think that's right, that he had to. The judge seemed to feel the political pressure to convict. And then once he had convicted, notwithstanding this young man's record and the facts of this case, he felt he had to send him to jail. I went crazy at that point. I saw my own sons in this case. As I said, I'd never let myself even see the other side remotely before, and I took the appeal. And one of the reasons why I will never do this again is what happened on this appeal. I really will never do this again. The issue in the case, the central issue in the case was access. The woman had made the first accusation of rape 9 to 10 months after the crime supposedly occurred. She had been institutionalized for taking too many cold pills, and she claimed that it was because she was sad about it. Her boyfriend had just broken up with her, and she just lost her grandmother. We sought to get access to her psychiatric records. The defense lawyers had sought to get access to her psychiatric records, not for the general purpose of finding out what was in her mind about everything, but because if the complaint was first made, we needed to talk to the person who first heard this version of the facts. It was nothing more complicated than that. The judge turned us down initially and said he would look at the records and we wouldn't be allowed access. On the appeal, all that we were arguing is there was no question that someone should look at it. Even the judge agreed someone should look at it since this was the, quote, fresh complaint. And we were saying the judge doesn't understand the implications of the case. The defense lawyers, subject to all the requirements of confidentiality, we didn't have to tell anyone else, had to look at this to see how it was that the complaint was made. What did she say? Did she say, for example, I was seduced the first time and then, 3 or 4 weeks later say it was rape? How did she say it? How did she describe it? Did she talk about somebody else initially? Because this was terribly important, and had she made that statement outside of a psychiatric hospital, we would have had access to it. The judge's decision, and I think in part, I say immodestly because I think they trusted me because of my reputation, went far beyond what we asked for. The judge's decision was that thereafter there shall be access to psychiatric records by defense lawyers in all rape cases, in fact, in all cases now. It was a result that I found abominable. And as an advocate, I found abominable. When a woman is raped on the street by a stranger, has post-traumatic stress disorder, 2 years later seeks a psychiatrist, the defense lawyer has no business looking at that. It has absolutely nothing to do with the case. It's solely for character assassination. It has nothing to do with the case. Now, the rules regarding the admissibility of evidence hasn't changed, but still there's something terribly troubling about access to this information. The problem is when you're an advocate, you don't control the outcome. And one of the reasons why I wanted to speak today is that and one of the reasons I'm participating with Lynn and talking to judges about this is that I want to control that decision. It was absolutely far broader than what we intended, and I think not justified by the facts. But it happened, and there you have it. The upshot of all of this is that I believe still that the system, the juries, the prosecutors are still responding, and Alan Dershowitz apparently as well, to the myth of the false accusation, as if that is the major problem, and not the concern for the unredressed accusation. But that also doesn't mean you have to step back every once in a while and recognize that there are still false accusations. The system should not be carved to assume that that's the norm, and that the protections of the criminal justice system where liberty are at stake are cruel to the victim, but in some measure necessary. And the major fight here has to be in the public.
Let's see if I can do a little better on my scribbled notes this time. Our next speaker is the Honorable Leslie Snyder, who is on the New York State Supreme Court. She was the founder of the first sex crimes prosecution unit in New York County, and she has also been the author of several laws, including New York's Rape Shield Law, which was passed in 1975. She's also presided over many rape trials, and I want to add a personal note that I just noticed that she's also receiving one of the alumni awards at Reunion this year for Radcliffe.
Sometimes I get sick of judges being blamed for almost everything. But probably a lot of it is justified. I'd just like to begin with a couple of notes of my own on history. And sometimes maybe we get bored with history, but it can be very revealing. I tried my first rape case in 1970. That is, I prosecuted my first rape case in 1970. And we didn't know very much about rape in those days. This case was a vicious double rape, sodomy, and robbery case. I tried it in front of a very old-time, old male judge. In New York, we had the typical technical corroboration requirements. You had to corroborate identity, force, and penetration. We corroborated identity as to the sex crime. We corroborated force. However, as to the element of penetration, the semen was found inside the victim's underpants as opposed to inside the victim's vagina. The judge threw out all the sex crimes cases, charges at the end of the prosecution's case. Fortunately, the defendant was also charged with robbing each of these victims. He was convicted of those charges most appropriately and sentenced to a substantial time. And P.S., I learned about 3 years ago that he was being tried again for another rape case, having gotten out of jail on the case in which I had prosecuted, which was a very sad and upsetting note to me. But that was what the law was like in 1970. Obviously outraged. I was in the New York County District Attorney's Office under Frank Hogan in those days. We discussed this case. We discussed other rape cases. Nobody really knew much about rape. And we started working on having the laws change. We started working with the police, and we really started caring about these crimes because to me it was incomprehensible that in this area women had to supply all this additional proof, and it was the only area, and it's usually women, and it was the only area in which this was true. Well, between 1972 and 1975, we had the laws modified, and then ultimately corroboration was eliminated. Meanwhile, however, what was going on in the courtroom in those days? Victims on the witness stand, the victim was always the focus of the trial. I think it's gotten much better in many cases now. We'll talk about that briefly. But the victim was the sole focus of the trial because there weren't any rape shield laws. So that the defendant almost became the forgotten person in the courtroom. I have to say this, Nancy, I really think the defense has gotten so much the better deal in sex crimes cases and still does too often. So it's hard for me to be sympathetic to the defense sometimes in this area. But judges absolutely never put a stop practically to cross-examination of the victim. The victim would be asked in many cases to describe every sex act she had ever engaged in. In one classic horror story, the victim was on the witness stand for 9 hours describing various sexual acts. I guess she had participated in quite a few of them, but they had nothing to do with the crime charge. They had nothing to do with the defendant. They were absolutely and totally irrelevant. And I popped into the courtroom from time to time when I had a moment, and the judge was just sitting there doing nothing and not sustaining any objections. The victim, 9 hours. So we decided we had to do something, and we were beginning to get together in women's groups and doing things like having rape counselors. This was all new in those days. And ultimately, another woman and I wrote New York's rape shield law, and that law should be discussed because it still isn't being used as much as it should be, but it has been a great help. So at this point, we were beginning to understand rape a lot better. We were trying to educate people to the fact that rape was not primarily a crime involving sexual gratification, but it was a crime of violence, humiliation, and degradation directed primarily towards women. Hopefully, we all know that, so it seems silly to say it now. But a lot of people still don't know it, and a lot of jurors still don't know it. And apparently, a lot of judges still don't know it. And that's something that we have to change. And so we did other things. In 1973, I was allowed to form the first sex crimes prosecution bureau in the country. And there hadn't been any. And the police department formed the first, in New York, formed the first sex crimes analysis unit. And so we began educating ourselves and attempting to educate others with a great deal of help from women's groups. And I feel that feminism was really beginning and on the rise in those days. We did a lot of exciting things. The problem is that here we are in 1992, and the question is, how much has all of this helped? Well, I think it's helped somewhat. But what's really sad is that today, this very day, on a tangent, but a related matter dealing with women's rights, the Supreme Court is probably going to curtail one of our most valuable freedoms until it doesn't exist anymore. As we know, the abortion case being argued today in the United States Supreme Court. And when in 1991, Anita Hill can basically be raped by a panel, a subcommittee of the Senate, and treated the way she was, in my view, we've got a long way to go. So what do we need to do? Well, as has been suggested, we need a lot more education. But it's not just of judges. Judges need it. And Lynn Schafran will tell you about some of her very exciting ideas on judicial training. But the problem is lawyers need the training. Prosecutors sometimes still need the training. And certainly the public needs the training because jurors are not adequately knowledgeable or sophisticated. There's still too many rape myths that everybody believes. Rape isn't serious if there isn't any physical injury. I could go on and on. I don't want to do that because what we're saying overlaps to a certain extent. Take the rape shield laws. There's no point in having them if they're not going to be enforced in the courtroom. Now, I'm afraid that too often judges are using savings clauses, which are necessary for constitutional reasons, which allow an exemption after an appropriate fact-finding to allow in questions about a victim's prior sexual history. But that's supposed to be the exception, and it's only supposed to be used in rare cases. The purpose of these statutes is to preclude questioning about a victim's prior sexual history unless it deals with the defendant or it rebuts a point that the prosecution has themselves brought up. And in extreme cases, the exception in a particular case in the interests of justice, after the court has a hearing and a fact-finding out of the jury's presence. But judges are sometimes weak and sometimes uneducated. Not all, but they will sometimes allow the defense to simply ignore the statute, basically, or not enforce it rigorously enough. And judges have to be educated in that regard. Another very important tool for the rape victim, and it's been touched upon, is to allow in evidence that we call things like the rape trauma syndrome, or RTS, or in battered spouse cases, the battered spouse syndrome, child abuse cases, etc. There are these syndromes, and they're absolutely devastating evidence for the prosecution. And when I was listening to Nancy, and I don't know the case you defended, but you raised certain factors that if someone had testified as an expert for the prosecution on the rape trauma syndrome, might very well have rebutted every point that you raised, such as the victim inviting the defendant over to the family house 2 weeks later. Two classic New York cases. It doesn't matter that they're New York because all of our states share similar experiences that I think you would find interesting. A victim is raped. She reports it. The police investigate. The defendant is arrested, all based upon apparently adequate evidence. The victim experiences tremendous trauma, psychological trauma, and she writes a series of letters to the defendant while the case is pending, awaiting trial. In those letters, she recants the fact that he raped her. She apologizes to him. She says, I made it up, I shouldn't have done it, etc., etc. Now, doesn't sound like a very good case for the prosecution, does it? The judge, in the first case in which it happened in New York, allows in an expert on the rape trauma syndrome. And maybe I'm not telling you enough facts of the case to make it sound as if the victim was raped, but you'll have to assume that there was ample evidence that, in fact, she had been raped by this defendant. But she still recants, and she even apologizes in these letters. Now, these letters are introduced by the defense. The judge allows in the rape trauma syndrome expert. The expert tells the jury, not allowed to say this victim was raped, not allowed to say anything like that. That's the jury's function. But the expert describes the rape trauma syndrome and describes the kind of reaction that a rape victim will experience. Recantation, not at all unusual. Denial, not at all unusual. Writing apologies, not unusual, typical of the kind of manifestation of trauma that a rape victim may experience. Does this victim suffer from the rape trauma system, in your expert opinion? Yes. The jury convicts the defendant. Without that evidence, that defendant would never have been convicted. As a defense attorney, of course, I would jump in if I were Nancy and say, well, maybe he shouldn't have been. But again, I'm telling you, assume there was ample evidence in the case that the defendant had raped that victim, but the letters would have been absolutely devastating. Similar case, trying to move along quickly. Also in New York, the victim denied that she knew who had raped her. But a few hours later, she told her mother, but she wouldn't tell the police till some days later. Once again, ample evidence that the defendant had raped this victim. But that evidence came out at trial. The judge did allow the rape trauma expert to testify and to indicate that denial of the identity of the person who had raped the victim was a typical manifestation of someone suffering from rape trauma syndrome. And in fact, this victim was suffering from rape trauma syndrome. Jury convicted the defendant. Now, if judges don't understand these syndromes and if they aren't willing to allow in this expert evidence when it is appropriate for the jury to understand victim behavior of a rape victim, which is not typical of the victim of any other kind of a crime. And that's why it's expert testimony, and that's why it has to be allowed in many of these cases, in my view. So judges must be educated to be sufficiently familiar and not afraid to risk the possibility of reversal if they feel the legal record does warrant this kind of testimony. And I think one of the things that Lynn will probably tell you is it doesn't happen often enough, and that's probably true. Now, how about how a judge controls the courtroom in a rape case? By his or her body language, by the language you use towards the victim, by the attitude of the judge towards the victim, you are sending an extraordinarily strong message to the jury of what you think of the victim. So you have to be extremely careful as the judge to be fair both to the victim and the defendant. Cross-examination of the victim, as Nancy said, has to be thorough, and it should be vigorous. That's part of our system, and it's only fair for the defendant to receive a vigorous defense and a fair trial. But there's a difference between a vigorous cross-examination and someone who is harassing, embarrassing, and badgering the victim. I will not allow that to happen in my courtroom, and there's no reason why any judge should allow it to happen, because there is a difference. Again, vigorous cross-examination, absolutely warranted. Harassment, embarrassment, demeaning of the victim cannot be allowed. And it's up to the judge to control the courtroom. Another very important factor in a rape case, and I'm talking about it now from my perspective as a judge, because I think judges do get blamed for everything, and judges are key to how the trial goes, and often should be blamed, but not always. When a case is, almost all these cases are tried before a jury. And the prosecutor should have the ability, as well as the defense, but now the prosecutor is the person who's usually denied sufficient leeway in this. Prosecutor should have the leeway to educate the jury adequately before the jury is selected to the problems in the rape case. So, for example, if it is an acquaintance rape case, and let's say the victim went willingly to 3 bars with the defendant, and then invited him to her apartment or went to his apartment, and then the rape allegedly occurs. The prosecutor must be able to explore this adequately with the jury before the jurors are selected, must be able to discuss with the jurors individually, can you follow the law? If you ultimately are convinced by proof beyond a reasonable doubt that a threat occurred, express or implied, that placed this victim in fear of physical injury or death, whatever, will you convict? Do you have an open mind about someone who may have gone to a bar, or 3 bars with a defendant and back to his apartment, who then comes in here and says she was raped? Can you keep an open mind, or have you already formed some opinion? And if you do what we call the voir dire, or the screening of the jury, if the process is allowed to be done thoroughly by the prosecutor as well as the defense, you have a much better chance of having a jury that will be fair to the victim as well as the defendant. And both sides are entitled to a fair trial. The Constitution only talks about the defendant, but both sides are entitled to a fair trial. And in my view, the judge must make certain that that happens. The death note has arrived, so 3 more minutes. The judge's role in sentencing also has to be talked about a lot more, because I think that Some of us who were rape prosecutors very clearly understand the nature of the trauma, whether there's physical injury or not, and will sentence appropriately. But we just had a case in New York over the last few weeks. A judge who will go nameless made certain statements which fortunately the media and women's groups called to everyone's attention. A mentally retarded girl was raped. There was no physical injury. The judge demeaned the quality of that rape. He indicated that he did not, he's a very nice guy, just doesn't understand rape. He indicated that this victim really hadn't had that much of a traumatic experience because nothing had happened to her. Well, he didn't understand, and judges have to understand. So much pressure was brought to bear on him that he convened a panel of other judges to discuss the sentence. Ultimately, he gave a very severe sentence, I think appropriate under the circumstances. And that touches upon the fact that I think that women's groups and the media can be extraordinarily positive forces. They create a lot of problems for us in the courtroom because we have to worry about the press not tainting the jury and not having to declare mistrials and other legal problems. But in terms of focusing, putting pressure on prosecutors and judges appropriately to understand these crimes and apply the laws properly and fairly to the victim as well as the defendants, the press and women's groups are absolutely key. One point about going through the criminal justice system that I feel I must talk about, having been a rape prosecutor for a number of years. You know, you can have a miserable experience. There's no question about it. But I think you should think very carefully about pressing charges. I think you should do it. And the reason I say that is, if you have a prosecutor who cares, then that prosecutor will make every effort to make your experience as untraumatic as possible. It's bound to be traumatic because you can't relive a terribly traumatic experience without experiencing trauma. But it's extraordinarily important, unless you already know that the prosecutor doesn't take certain kinds of cases seriously, or you know you're not going to be well treated. It's extraordinarily important because rapists are recidivists, because I feel you have a duty to other women and other sex crimes victims, and because the criminal justice system doesn't work well, but it does work. And our job is to try to improve it, not to say we're not going to participate in it because it's not perfect. And if you have a prosecutor who cares, he or she will make the effort to make it as untraumatic as possible. Unfortunately, there are prosecutors who are only interested in winning, and I've seen some of that in my function as judge for the last 9 years. I find it disgusting, but it does exist. And if your case is a quote-unquote date rape, which isn't going to make the papers, and there's not much chance of success, it may very well be dumped in the criminal court as a misdemeanor, and nobody gives a damn about you. If you know that's going to happen, then you may not want to proceed. But if you have a prosecutor who cares, and you have reason to believe you'll get treated fairly and adequately, I really urge you to proceed. The criminal justice system can't work unless we all try to make it work, and that's what we've got to do. Juries are still extremely skeptical of many kinds of sex crimes. They want corroboration, even though the law doesn't require it, unless there are physical injuries in many cases. But again, we have to educate them. We can't just throw up our hands in despair. Experiences with juries are very varied. We do get a number of convictions, even in date rape cases, and we as judges do sometimes take them very seriously, I can assure you. In general, I think we've made a lot of progress in this area, but far from enough. I think we have to keep focusing attention on it. We need more education of all of us, and your participation in your criminal justice system is key. We will improve it together, I believe.
I just want to tell you that we are going to go until close to 8:30. We're going to do, Lynn Shaffron is going to talk for about 12 to 13 minutes, and then we will have time for questions. And we saved Lynn Shaffron for the end because she is a person who is really doing a lot to change this. She is with the now Legal Defense and Education Fund's Judicial Education Project, and she is currently developing a model curriculum for judicial education for judges on rape. She's also been an incredibly important presence traveling all across the country, educating judges not only on this issue, but on many issues. Lynn.
Thank you. My job is to wind up this panel on a happy note by telling you some of the things that are happening to make the system better. Before I do that, I just wanted to pick up on a couple of threads that have been running through the evening's discussion. Leslie Crocker Snyder was talking about participating in the system and going through with a trial. I want to tell you that yesterday I had a conversation with a woman named Barbara Eggenhauser, who is in the sex crimes unit in Westchester County in New York, and she was expressing the same view that Heidi Kreitzer and Jeff Newman were expressing about the experience of having gone through that trial. And the interesting thing that she said was that even if the victim loses, quote unquote, going through the trial can be very empowering. So I certainly hope that none of you will ever be in a position of having to decide whether or not to go forward. The odds are that some of us in this room will be in that position and have already been in that position. So I hope that you will remember this evening's panel and just not decide not to go forward. But remember that it's very hard to go forward if you don't make that prompt complaint. When Lenore Weitzman was speaking about if you don't make a complaint within 1 to 3 months, you're presumed to be fabricating, try 1 to 3 minutes. I mean, they really want you to go straight from the attack to the police. That's what they want. You can always decide that you don't want to proceed with the case. You can never go back and go to the hospital and have a rape kit exam done. So as dreadful as it may be in that instant of denial and panic and pain and humiliation and all the other emotions that flood a person in this situation, you can possibly bring yourself to go to a hospital to have a rape kit exam done. If you don't want to run down to the police station and talk to a bunch of strange policemen, at least make a report to a rape crisis center so there is something on record. As I say, you can always decide not to prosecute. You can never go backward. Finally, you may be in a situation like the Tyson case, where the person who assaulted you is someone you know, and for a variety of reasons you feel some compassion for this person. And your sense of it is, if this person would get treatment, I would not prosecute. You may remember that Desiree Washington said this over and over again. It is very important that you understand that treatment for sex offenders is a very unique kind of treatment. Only in the last few years have people who worked in this area discovered that classic insight therapy, which is what we usually think of as therapy and mental health treatment, not only does not improve these people, it makes them worse, because it strokes their ego and tells them what good friends they are, when in fact they are into heavy denial and really bad attitudes toward women. I don't have the time to tell you tonight about what constitutes an effective sex offender treatment program, but I just want you to know that if you are ever in a situation where you want to say, well, go get help and we won't bring a case, you've got to know this is a very, very specific kind of difficult therapy, so painful that many men who go into these programs decide that after the fact they'd really rather just do their time in prison than have to look at themselves and spend time role-playing the rape as if they were the victim and going through this very harsh, difficult kind of therapy. And that's tremendously important, I think, for people to know, because there's a lot of misunderstanding there. Now, as I said, I'm supposed to end this on a happy note. So what I want to do is to tell you briefly about some legislation that is pending in the Congress. And it's been pending for 2 years. It will probably be reintroduced again in the fall. We don't think it's going to be able to move finally this session. It's called the Violence Against Women Act. It was originally introduced by Joseph Biden. Whatever we may think of Senator Biden in terms of the Senate Judiciary Committee hearings, the fact is that he did come up with this idea. And for various reasons, the now Legal Defense and Education Fund has become the principal technical consultant to Congress on this legislation. And we've created a coalition of about 300 organizations of every possible kind: women's rights, victims' rights, religious, labor, peace, you name it, which is working with us to refine and improve this legislation. In the House, it's being sponsored by Barbara Boxer. There are some changes in the House and Senate version, but essentially they're very similar, and I'm going to run down them for you. Mandatory restitution, treatment, and rehabilitation for sex offenders. The defendant is going to pay restitution to the victim, and there's going to be specialized treatment, as I've just mentioned to you. Grants to the states, law enforcement, and so on to improve law enforcement, prosecution, record keeping, and victim services. Grants to improve public security in public transit and in public parks. Creation of a National Commission on Violent Crime Against Women. Extension of the Rape Shield Law to all federal and civil criminal cases, and making evidence of the victim's clothing inadmissible in federal court to show that the victim invited sexual assault. Now, usually evidence of clothing is going to come in anyway for a whole variety of reasons. The prosecution may want to bring it in to show that it was torn or whatever. But there was an infamous Florida case in which a jury acquitted a man who kidnapped and raped a woman at knife point because, said the jury, her clothing was provocative. So Florida adopted a law saying that the defense may not introduce clothing for this purpose, and that was picked up in this federal legislation. $60 million and then 75 escalating monies allocated for rape crisis centers, $5 million allocated for rape demonstration projects to change relevant attitudes of boys and young men, teach nonviolent conflict resolution and self-defense in schools, and reduce the trauma and long-term impact of rape. This grows out of some work that's been done with school children. In Rhode Island, for example, a rape crisis center there began doing some surveys and studies with youngsters in schools and found overwhelming attitudes on the part of girls and boys that basically if a guy spent $15 on a girl, he was entitled to sex. And if he was married, he was entitled to sex all the time, no matter what, in any situation. And after going through some training provided by the rape crisis centers, the attitudes of most of these children changed markedly. And those children are the juries of tomorrow. So if we think things are going to get better, they are not going to get better without very serious, concerned and focused attention on re-education. Then this legislation also addresses a lot of issues around domestic violence, which for the moment I'm going to pass over because we're focused on sexual assault tonight. There is a Safe Campuses for Women section, which deals with model demonstration grants for local rape crisis centers, a written code of conduct for students that explicitly prohibits rape and sexual assault, and must implement a policy whereby sexual assault victims are informed of the outcome of campus police investigations and campus disciplinary proceedings resulting from the victim's complaint. This is a real problem. Jeff Newman and I were talking about this before we began tonight, about how schools are handling complaints internally. When do they have a right to throw someone off campus? What do they have to do? Do they have a conflict of interest? They don't want to throw the guy off campus because they want his tuition. Very interesting things to consider. Closes a loophole in the Crime Awareness and Campus Security Act of 1990 by requiring that colleges and universities release statistics on sexual assault as well as rape. And then finally, the last title is called Equal Justice for Women in the Courts, an allocation of funding to train federal and state judges on crucial issues arising in rape, domestic violence, and gender-motivated crimes. One of the things I passed over, I'm sorry, is the creation of a civil rights remedy. This is about the only piece of this that's very controversial. A lot of the judges are not happy about the creation of a federal jurisdiction for certain interstate kinds of crimes, and then the creation of a civil rights remedy, which would deal with gender-based crimes. And the most direct example I can give you is many of you may recall an incident 2-3 years ago in Montreal where a guy went to an engineering school and picked out all the women students and said, "I hate feminists, die," and shot a goodly number of them. And there was no question about what his motivation was. The judiciary is saying, well, the federal judiciary, we're burdened, we're overwhelmed, we don't need this. We're saying, yes, we do need it. There is a huge amount of evidence that state courts are not dealing sufficiently well with crimes of sexual assault and domestic violence. And why is it that every other ism has got a civil rights remedy except us? The work that I'm doing just at the moment is under the auspices of the State Justice Institute. I have a grant to create a model judicial education curriculum for judges on how to try a rape case. And this will be designed to be the generic model that can then be used by individual states to match their own statutes and case law. You know, some states use the word rape, and some states use the word sexual battery, and some states allow rape trauma syndrome in, and some states don't, and some states permit a man to rape his wife under any circumstances, and some states don't permit it under any circumstances. So the variations are enormous. But one of the things that we're going to try to do in this model is to revive voir dire, the jury examination that Nancy and Leslie have talked about as being so important. This is something that's been under attack for 25 years because in terms of judicial economy, the judges feel it takes a lot of time. But when you just, line up the first 12 people and they sit down and they have this freight load of stereotypes that they come in with for a rape case, are we surprised that we get just some incredible verdicts? I mean, we had a situation last year in New York where a black woman on welfare went to a white physician who had a clinic for an obstetrical examination. She believed she was pregnant. He raped her on the examining table. He denied that he ever had sex with her. When the DNA results came in, he said, well, I had sex with her, but it was consensual. And after the acquittal, a member of the jury wrote the prosecutor a letter and said, well, we felt that a black woman like that might feel flattered by attention from a doctor. Okay? So, everybody is worried about people are saying, was Mike Tyson railroaded? I mean, one of the things I am working on in this curriculum are all the issues of rape and racism, and there is certainly no question that the racism directed against black men in sexual assault trials, black men accused of raping white women only, has been one of the worst chapters in American history. But we seem to be forgetting that there are black female victims. And if you want to really see racism operate in this country, there are jury studies which show that black women are the least believed of all, whether they are alleging rape by a white man or a black man. Because if you read the whole evolution of how black women were treated in the South and the repeated rape of black women and the fantasy of black women as being promiscuous in order to promote certain fantasies of black men. I mean, and we don't have time to go into this whole history here. But the fact is that we saw in the Clarence Thomas case, this was a high-tech lynching. Anita Hill is a black woman. Where did her race go in this case? I mean, it just disappeared. So we have an enormous amount to do with the jury, and we also hope to deal with just the whole range of issues that we've discussed tonight. Sentencing problems, admission of rape trauma syndrome, and the changes in public, in mores. One of the real problems we face is jury instructions because those were written before there were such a thing as prosecution for date rape, and they're all really written in the context of stranger rape. And there is no jury instruction that says a woman never loses her right to say no, and you really have to say that to these juries because, as you said, if she went to 3 bars and then she went home, well, isn't that implicit consent? And you have to point out that the statute does not say that it's, there is such a thing as implicit consent. I have hopes that we will be able to make some headway with this. I will tell you that there was a program a couple of years ago in Wisconsin that grew out of a real scandal in the community where a judge told a rape victim who was crying on the stand that this was no big deal, and if she didn't stop crying, he would dismiss the case. And out of that grew a judicial education program just done for that community. And the judges were so fascinated by this program that they literally stayed in the building until the janitor threw them out. So I hope that that's an indication of the expression of interest that we're going to find around the country. And I would close by saying 2 things. Number one, Massachusetts is one of my pilot states for this program, so I'll be very interested to see what happens locally. And secondly, with respect to the Violence Against Women Act, all of you come from all over the country. You are about to disperse for the summer and go home. I hope that you will, during the summer, work on your respective congresspeople to get behind this legislation. The Now Legal Defense and Education Fund has a whole little packet called the Campaign to End Violence Against Women. It describes the legislation. It describes what you can do about it. I'd be more than happy to provide this to any of you because you are really the key to seeing this passed. Thank you.
Okay, we're open for questions. All the way in the back there. Yes.
Question about the legislation. I would like to know if there's been any consideration about how a victim is being paid restitution. I would think that if it were set up such that the female receives payment on a periodic basis, that each time she would receive such a payment, it would be reliving the whole situation again. So I would like to see if, the legislation is approved there, that some type of payment option set up, or really no option, just that a lump sum type of payment to be made as opposed to something periodic, which needs to be a constant amount.
Okay, I don't know how it's set up. It's a very interesting point, and I will certainly write this down and take it back to our office and raise your idea with them. Definitely. Yeah.
Are there any common personality traits among male race?
Yes. Oh gosh, 25 words or less. Okay. There are people who do sex offender treatment have divided rapists into, I hope I get this right, I didn't bring this material, ego, power, there's one more I'm missing, and sadistic, okay? And, pardon? Hate their mother. Well, this does come into it, and, very seriously, it comes into it in the sense that when you read about what you ought to do if you are assaulted, how you might deter this person from going forward, if your thought is, well, if I tell him, think of your mother, think of your sister, think of your wife, that could be the very worst thing you can do, because we have cases in the literature, many of them, of guys who get mad at their wives and go out to rape women as revenge rapes on their wives. So the problem with this literature and these profiles in terms of giving counsel as to what to do is that it's like you've got to figure out in 15 seconds or less, is this guy an ego rapist, a power rapist, a sadistic rapist, what do I do? And Nicholas Groth, who's one of the pioneers in sex offender treatment, and he's in one of his articles where he goes into this in some detail, he ends it by saying, I really feel after all this, I just cannot give people good advice as what to do. But we do have evidence that making some effort to resist screaming, yelling, and so on does have some deterrent factor. But the most important thing is to survive. And if you think that the best way that you can survive is not to do anything, then that's the best thing to do.
Actually, I want to add one thing to that all these studies of offenders have been done on convicted offenders. And if we really believe the data on the lack of reporting, then they're based on a very particular type of rape and a particular type of offender. Yes?
Well, I'd like to say that Veronica Wright is here from the Israel Rape Crisis Center, and in one of our workshops this week, she discussed the 4 types of rapists. I don't know, voluntarily.
You got them all just about right.
Good, I missed one.
There's aggression, the aggressors, those are people who are motivated out of anger. There's the power rapists, those are the people who are motivated to dominate and control and humiliate their victims. There are the sadistic rapists who are the most lethal in terms of what they will do to a victim. And then there are the opportunists who are considered people who go out and are committing another kind of crime, and in the course of committing that crime, they may commit a rape.
It's called bonus rape. That's the line. Really, that's the phrase that's used. I went to take the TV and I got a bonus.
Now they're coming out unacquainted rapists, and in fact, on May 1st, there's going to be a conference here at Harvard on educating men about rape, and Gary Gertner, who's a researcher from Georgia, is going to be presenting his research there. I think that this is just the beginning of our understanding of what's true. The incarcerated rapists are a particular type, but that many of the characteristics that they have
Elizabeth Schneider, who's
Let me just repeat it. The question was, has the rape trauma syndrome ever been used against women if a woman doesn't exhibit the characteristics of the rape trauma syndrome?
Well, just, Nancy, maybe you could speak to this too. Elizabeth Schneider, who really did the beginning work on self-defense cases for battered women, has pointed out that there's a difficulty in creating battered woman syndrome and creating rape trauma syndrome because not everybody reacts exactly alike. And once you create this syndrome, it's so easy to say for the judges, and they do this, they say, oh, okay, these 5 behaviors, that means she was raped. And if she didn't, exhibit those 5 behaviors, then that's used against her. So these things are problematic.
I don't agree with that at all. I mean, the point about the rape trauma syndrome is that it's used to describe abnormal reactions by victims of a crime which has a totally abnormal effect, not abnormal, but extraordinary effect on the victim. So I don't really see it's being used that effectively against the victim at this point, because it's done more to explain that each victim can react totally differently and what might be viewed in a totally unusual and unexpected manner. So as a judge, I would not let it in, probably, in the sense you seem to be indicating, because I don't see how it would be admissible. But it would be we'd have to discuss it at some length.
It's also the case that the syndrome itself is not, I don't think it's ever been tested in Massachusetts in particular. I mean, it's not regularly admissible exactly because there are women who have different reactions, because it doesn't necessarily point to who did it. In other words, it's a reaction that speaks to the woman's point of view. It doesn't necessarily indicate she was raped by that particular person, obviously. So that there are problems. But what you're describing is the general pattern here. I mean, essentially, all the rules that we've been talking about are of the form of a sentence that goes, women who have been raped behave X. She behaved Y, therefore she was not raped. And in the past, it was women who were raped, it had fresh complaint or complained immediately, or women who were raped were virgins or something like that. And what we're doing is slowly as a society, and one would hope, changing the content of those sentences. And the rape trauma syndrome is really one way that we're trying to do it. If so much of this panel is on education, it's really, that's where it's at. Because ultimately, for example, the message of the Anita Hill situation was, yes, we now regard sexual harassment as terribly significant, but women are losing the trials. And it really is the same thing about date rape. We wouldn't.
The question is, how is a therapist having sex with a patient considered? Is that considered criminal or civil? Is that what your question is?
I should say first, do you consider that within the realm of rape, like the woman who went to the gynecologist or between a husband and a wife, it's an unequal relationship, to be more unequal than a date rape or a rape on college?
It's what I was saying is that that's a situation, going back to my continuum, where the woman says a form of yes, but we understand that in the situation it is impossible, or that it is wrong to consent, or that it is in fact, it's very much as like statutory rape. A child, will say yes, but we say she can't consent. It is a matter, it's being debated now about whether or not that should be made formally criminal, but in that sense it's different than what we're talking about here, because here a woman is saying no, or she's saying nothing. No one has yet reached the point where a woman who said yes in a date rape situation but meant no could still prosecute for rape.
Jeff, did you want to say something on that? Yeah. Well, we're going to get you one more answer, and then I'm going to move on. Okay.
I think the direct answer to your question is, technically, there is no statute on the books which says presently that a therapist who seduces her patient and the patient then effectively consents is criminal. However, there can be cases brought by district attorneys on those very facts if they are brought to their attention and they're analyzed in such a way that a person cannot consent because they are under a mental disability.
Well, can I just mention real
Sure.
quickly? I know you
I'm going to let.
But you might be interested. In terms of advancing legislation, there is a new proposed rape law in Canada which says no consent is obtained for the purpose blah blah blah. The complainant engages in the activity by reason of the accused's abuse of a position of trust and authority. So that would criminalize the situation you described.
Allison?
Something I want to clarify. I've heard in the past, and I don't know how true this is or not, but if anyone on the panel would like to address this, that part of the difficulty in prosecuting rape cases is due to the severity of the sentence. And part of this past recollection that there was some movement to try to change the sentencing process to make this a more easily prosecutable crime.
I don't think that has anything to do with it. It would be very few jurors who would really know what the sentencing scope was, in my view. First of all, they're not allowed to know about it in a specific case, and it would take a very sophisticated person in each jurisdiction to know what the length of sentence was. Now, the defense always tries to interject lines like, you know, his life is at stake, and it's true that, you know, someone could go to jail for a very long time. That's not allowed, and the judge has to keep the jury's eye on the target, which is have the people proven that this defendant committed this crime by proof beyond a reasonable doubt.
But
and a good judge does that. And I don't think it was, but the problem, if I can just finish, I don't think that the solution is to change sentencing, because there is a broad scope in most jurisdictions as to how you would sentence on a rape case. And you need the sentencing potential for the kind of rape case that needs that lengthy sentence. So I don't think that's the answer myself.
There had been, I think, 10 or 15 years ago, a sense that when, in some jurisdictions, for example, rape was a life imprisonment felony. And that then led to a move to have degrees of rape, in part so that people would have a sort of full panoply of punishments available. But there's no question that I think that if this was always a life imprisonment felony, it would affect the way people, all the participants in the system would deal with it. So that it might reflect our sense of outrage, but it would have several serious practical implications.
It could also affect prosecutorial discretion.
Sure.
Did you want to speak to that?
Well, I think that juries occasionally have a concern about punishment. If it's a case in which they're, say, not really feeling strongly that a defendant should receive any kind of a severe punishment, then that may be a factor that they will inappropriately utilize to say, well, if we convict, you know, he may face jail, he's 17, we don't think he should go to jail. Those should not be jury concerns, but juries are human, and if it is a case in which you have a particularly young defendant or they don't feel the crime is serious enough, not just in rape cases, they will use that as a reason not to convict.
I understand how having different degrees might help that, but it still seems that there's a denial of the fact that something actually happened, rather than accepting that it happened and doing something about it, whether getting treatment or getting it on its record so that it happens again to the offender, that it's denied completely. And is there any way you can bring that into kind of pretrial instructions of the jury?
What exactly is it that you wish to bring into the pretrial instruction?
That there is a difference between convicting someone of having done the crime, but suggesting that a lesser sentence be given for.
No, it's a difficult area, but basically a standard instruction given prior to going into any evidence in New York, and I'm sure in most states, is that the jury, in being informed of its function, is told that sentencing has nothing to do with its function, that the court will impose a sentence if there is a conviction as a matter of law with the appropriate information before it, and that the jury is not allowed to consider it. But juries don't always listen to these admonitions, but I don't know how else you could do it, really.
I'm going to allow for 2 more questions, then end. Madhuri?
These men were already asked about the press, and I just have a couple of concerns about your answer. Basically, I'm an editor of Exemption, and it's actually a debate right now among our editorial staff whether or not we should press for having the imprisonment be allowed inside of ad board proceedings on basically the same date rape cases. And actually, the people who have suggested it are a group of male editors who are basically have admittedly said that they want this for the reasons of protecting the rights of the accused. And my concern, I mean, Judge Conner, you addressed this too. I see how having the press in the room, watching the actual procedures and everything can be beneficial to all parties. But my concern, specifically here on a campus, is will this scare more women and make them really fear coming out, especially when it's a small community, and even without having their names in the paper, people will be able to probably easily identify them. So I wanted to ask what you thought about that on the college campus.
Well, presently, there is now a United States Supreme Court case which says in normal courts the press is allowed in. And there is an informal, unwritten ruling now among the Fourth Estate that they don't use the name of the victim. It doesn't mean necessarily that if the press is in that they have to print the victim's name. And that I think on balance it's much more effective to have the press there because from what I know about the judicial board proceedings from my limited experiences, they're grossly unfair, for example, that the alleged assailants are provided counsel or allowed to bring in private civil counsel hired generally by parents, high-powered lawyers, and the victim is not. So that I think it's going to balance out overall, and I think that there are safeguards which can be provided. However, I can see the problems where no one's been convicted of a crime, it's only an allegation, and it could ruin reputations and so forth. In the end, I think it's better to have them there than not.
Does someone want to clarify the procedure before the ad board at Harvard? My understanding is that nobody can bring in counsel.
That's usually, most universities, in fact, in this state, don't allow private counsel on either side.
Yeah, I think that's so.
I think it's a difficult question. I think that it is a difficult question for both the woman and for the man who is accused. Ad board proceedings in most of the universities that I know are essentially kangaroo court proceedings that protect neither party very effectively. So I'm not entirely sure that that either the accusation was made and failed is something that a woman would want to have passed around, or the accusation was made and succeeded. Whether that would, now the other side of the coin is that airing these things publicly will make the proceedings better. I have my doubts about that. I think that universities are pretty resistant to change. And this one,
let you ask a question, and then Jessica, as the organizer of the panel, gets the final question. Okay? Let her go first. Go ahead.
Okay, you've all addressed issues of changing shifts in cultural mores. You've all addressed issues of education, lawyers, prosecutors, defense attorneys, general public, media. I'm curious what your sense is about the changes in technological advancement regarding rape cases, DNA testing.
Well, DNA is really, it's going to be used, all this crazy controversy about the latest report, things will settle out. But what's happening now is that because of DNA, the most bizarre cases are ending up being consent cases. This case that I spoke about in New York of the doctor who raped this woman on the examining table, it would have been a flat-out denial. I never had sex with her if the DNA had not shown him to be a liar. I recently read an article by a guy who's setting up a DNA lab in New York City, and this is just resulting in. I'm hesitating because in my head I'm running over the facts of some amazing cases which we don't have time to discuss. But basically, total strangers are now alleging consent as their defense because They can no longer allege misidentification, and they can no longer allege nothing happened. So there is no other defense except consent. Once you absolutely prove that this is the person who deposited the semen, and that's where we're going.
You will certainly be seeing a lot more of it, and I think it's a great tool. The problem with the consent defense is that it always seems to get to some jurors. They love to try to believe that the victim, for some unknown, incredible, and totally unbelievable reason to most of us, because it defies any kind of rationality, consented. And that's always been a problem defense for the prosecution in the most ridiculous situations.
But I think that the nub of the issue about changing sexual mores is in the date rape area, for which DNA is largely useless. In other words, where the cases concede a sexual relationship and everything turns around the issue of consent. So all of that highfalutin stuff is helpful in areas where, to some extent, juries are already more sympathetic. Total stranger rape situations, it's more helpful along those lines. But the real issues, I think, that at least I'm concerned about, and many people here are concerned about, is where we can draw the lines in acquaintance rape.
I would just like to add, in the only case in this Commonwealth that's ever been looked at in terms of the DNA testing, our Supreme Court has rejected it in terms of its reliability, and that that case stands as our law at this point in time, and that there are some questions now being raised by some noted scientists as to its reliability.
Yeah, it's a question about the standards. They vary from lab to lab, and that's been, I know, raised as an issue in a number of states where it is actually used.
But it's bound to be moving in the direction that the fingerprints and the like moved in, that's all. And so we're along the line now, but I think that it will change.
It's allowed in New York just because of battle of experts, as to things like the standards. But I think it's definitely the wave of the future, and it will be more perfected as to the imperfections. It's a fantastic tool.
You're passing. Okay, so. Okay, let me thank our panel for a really stimulating and exciting evening. Thank you very much.